Okay, hi everyone, it's Grant Abbott speaking from I Love SMSF and LightYear Docs, and I must admit I'm still recovering from the 3 weeks on the road, but it was, from my perspective anyway, very, very successful. And we had a lot of fun and went through 20 strategies, and I've just done up an email this morning that looks at all the various aspects of the 20 strategies, but more importantly, the slides. And a couple of webinars we've got coming up. So this time next week, so today we're doing the enduring powers of attorney. I'm going to have a look at some of the laws around it, just briefly. I'm going to go into the site, and I've already created one for myself. So I'm going to show you the one for myself, which is a Queensland EPOA. Currently, we've got EPOAs for every state and territory. I just haven't put up Northern Territory at this stage, but that'll be up in the next day or so. So you'll be able to go to Victoria, Queensland, New South Wales, West Australia, South Australia, ACT, and soon to come is obviously Northern Territory and also Tasmania. So they'll all be out and about very shortly, all again just for $99, and we'll go through various aspects of that. This time next week, which is a really important one, so that's on the 7th of November. Can you believe it's Halloween today? But on the 7th of November, effectively we'll be looking at wills and testamentary trusts. The ones I showed you on during the strategy day, we'll actually be going through that, how to do our fact find and also our data capture in order to ensure that effectively we've got a great will and set of testamentary trusts for our clients. And there was a really good article the other day I saw by Chris Hill from Hill Legal, talking about the importance of estate planning for accountants and financial planners to be in that data capture process. But I'll talk about the process and how you get a legal sign-off for it next Thursday. Then the following Thursday, I'll be doing the binding death benefit nomination, or what I call an SMSF will, because it really follows along the lines of will. Sorry, that's my other participant. So unfortunately, he's a bit of a nonger sometimes. Good lawyer, but a bit of a nonger. So when we go down that track, we'll find that the binding death benefit directions follows very closely the will. So there's specific bequests. There's also an ability to do pensions and also lump sums. And when I mean specific bequests, for example, we can transfer a farm out, a commercial property out, so on and so forth. So from that perspective, what we'll do is I'll be rolling that out, and that's very close, what I call an SMSF will. And we'll also look at the big estate planning project, or the big estate planning package, which has 12 documents. We'll look at that on the day as well. So that's on the 14th. If you haven't registered for that, just make sure you can do that on the LightYear Docs website. But anyway, let's move on and just go through quickly. I'm sure many of you have already done enduring powers of attorney, which I have in the past. So each state has its own attorney laws or powers of attorney laws that are enacted by that relevant state. So it's not a Commonwealth government issue at this stage. So when you do a EPOA, it has to blend in and be in accordance with the laws of that state, obviously. Now, if I've done a EPOA, which I have done in South Australia, and I've now moved to Queensland, even though I'm a resident now of a different state, it's still classified as being effective for Queensland purposes. But notwithstanding that, obviously, I find that the Queensland long form EPOA, as you'll see, are very strong ones. So I'll be putting in place a new enduring power of attorney this weekend, actually, when my daughter Sophia comes up and stays with her father. So that'll be a bit of fun. So again, they follow through, and from that perspective, it's it's a pretty useful situation. Seeing Tony is online, which is good, and I'll get him up a little bit later on. I've just muted him because obviously he was talking in the background with his family and his spouse probably doing enduring powers of attorney for them all. Now, when we have a look at it from a state perspective, it's going to depend on what the relevant state law is. So, for example, in Queensland, you can do your mental and, health and personal, and then quite separately your financial. Whereas other states you can do the whole lot all in one and virtually give you power of attorney, the power to do anything that they see fit. So, as I said, you can do health and ensuring principles looked after. It can come in, depending on how you complete the form, can actually come into play on the capacity for health, but basically for finances straight away. And certainly when we get down to SISA, potentially straight away as well. One thing that we'll look at a little bit later on when we have a chat with Tony is that there needs to be a letter from the doctor to show it's mentally sound, but I'll let Tony carry that one through a little bit later on. So if I now go to the SMSFs, self-managed super funds are quite distinct, and you can see down the bottom there, the Commissioner's ruling 2010/2, which is great reading for, well, I'm sure you probably guys don't find it great reading, but I like reading it because it goes into quite a lot of aspects of enduring power of attorney, particularly if we go overseas and we no longer want to make sure we're not a non-resident fund, that we're an Australian superannuation fund. So it covers a lot of those sort of aspects. What I'll do is I'll just go into the legislation while we're here, and for those who've just been on the roadshow, you're probably well aware. You can see there's a nice little rural property lease that we're looking at the moment. So that'll be out in the next couple of weeks. Again, that's just part of our, for those of you on unlimited docs, that's just part of the process. So we're continually adding documents to the system. So let's go down here and have a look at section 17A1. I'll go through, and some of you are on the roadshow, so you've probably seen this, but we may as well go through it again. So subject to this section, I'll just get my little annotator here so you can follow the bouncing ball, which I love. So subject to this section, the superannuation fund, other than a fund with only one member, is a self-managed super fund if and only if it satisfies the following conditions. It has fewer than 5 members. Now that will go up to fewer than 7 members, hopefully by early next year. The legislation's been drafted, just hasn't passed through both houses of Parliament. It needs to be reset and reintroduced into Parliament. So make sure all of you join up the SMSF party so we can push that through. Now, D is the one that I've highlighted. So we're all aware of this, and this is sort of ingrained for all of us who worked in SMSFs. This has been ingrained into our psyche, ingrained into our neurons for forever and a day, that each member of the fund must be a trustee of the fund, or if the trustee of the fund is a body corporate, is a director of a body corporate. So that's the linchpin for many of us, and we're all aware of that. Now, what I want to do is just show you that's all members must be trustees or directors. But notice this one, certain other persons may be trustees. So I'll just highlight that one. So certain other persons may be trustees. So they are people who are not members. Subsection 3, 17A subsection 3 says the super fund does not fail to satisfy the conditions specified in sub 1 or 2 by reason only that. I'll look at this next week. This is when we go into death benefits. B, the legal personal representative of a member of the fund is a trustee of the fund or a director of a body corporate that is a trustee of the fund in place of the member during any period when the member of the fund is under legal disability. So that's, for example, mentally incapacitated. Or, and this is important, this is absolutely crucial, or the legal personal representative has an enduring power of attorney in respect of the member of that fund or a member of the fund. So under the laws, and if I just go up and we'll have a look at what legal personal representative is, so we'll just go to section 10.1 and we'll have a look at the LPR. So that should just be popping up very, very shortly here. So when I have a look at legal personal representative, that should just be a little bit further here. Legal personal representative means the executor of the will or the administrator of a estate of a deceased person. That's not the case. The trustee of the estate of a person under legal disability. So, for example, may well be the public trustee, or for us, a person who holds an enduring power of attorney granted by a person. So, for example, where we have an enduring power of attorney, then that person will be authorised in order to be our legal person representative and hence step into the role of trustee and also director of the corporate trustee. However, and this is a big but, and you can get this from the ATO ruling, we've got 17A3B2 provides a member trustee, obviously an EPOA can be a trustee or director. Now, what happens though in the process is, as shown in the Commissioner's ruling, that just because you have a power of attorney, you can't be a trustee. So having a power of attorney can't make you a trustee. Having a power of attorney can't make you a director under the Corporations Act. What needs to happen, and this is imperative, and this is why the SIS Act is absolutely crucial, that we cannot act as an attorney, we need something more. And for that place, if we're a trustee and we've got someone who wants to do an enduring power of attorney, who's got an enduring power of attorney, I need to resign as trustee or resign as director, and then either the board of directors or the existing trustees or the mechanism. For example, in the two deeds that I've written, we're elected by the member. For example, someone going overseas or simply want to have an enduring power of attorney, they can automatically appoint the new person as a trustee. So you don't need to have a trustee meeting. They'll simply say, well, I'm out of here, I'm resigning. And part of that resignation process, I'm hereby appointing, for example, in my instance, Amanda and Sophia, which is my wife and my daughter, as my directors of my corporate trustee. And so that needs to be put in place. So the fact that my enduring powers of attorney, they can't come in and act as a director, they can't do that. There needs to be a process within the deed for it to go through. And as mentioned in the Commissioner's ruling, you can't just act as agent for, so they can't come in and say, well, I'm acting as an agent for the trustee. They need to be specifically appointed. So from my point of view, as opposed to the state-based laws, we can act as a power of attorney for anything. They give you the power of attorney, but we need something more in order to have that ability to be appointed as an enduring power of attorney. And again, that comes down through the process of what's sitting in the deed. So let's go through and have a look at the enduring power of attorney. I've got here, so this is one I did before. I'll go through, it's just a bit easier, sorry, because my typing's hopeless for those of you who've seen it. I'm now living in Queensland. So what I'll do is I need to relaunch this. So what I can do any point in time, if you're looking at it for the enduring powers of attorney, what we do is effectively we go down, we find that they're in the estate planning section. So you can see we've got ACT, Queensland, Western Australia, Vic, South Australia, New South Wales, Northern Territory, and also Northern Territory and also Tasmania will pop up in the next day or so. This will then follow next week by wills and testamentary trusts, and then obviously an SMSF will following after that. So I could go through the process. Because I'm unlimited, I can easily start the document, then I'm off and running. If I wanted to, I've got to put it in my folder. So I've got it in the Abbott-Family folder. I could start again if I wanted to do that. But what I'm going to do is, rather than create a new one, which I've got there, what I'm going to do is just go into, you can see there, my in progress docs. It's important when you go through save answers, but let's go into the vault. So this is one I've done before. I'm going to go down and have a look at the Abbott-Family, which you can see here. I click on that. So it's important when you do create a document that you do name it and it sits in the vault, so it can be accessed a little bit later on. And I'll have a chat with Tony on that very shortly. So what I've got here is enduring power of attorney. I click on that. That's the one you can see I've done this morning. It was created on the 31st of October at 8:28, so that's very shortly. Now it's Queensland time. I can download it, I can bin it, or I can relaunch it. So this goes into our system. And again, for those of you who've heard me, this is a legal interview system. So I've got the EPOA there, I've named it. So let's go to the first page. So Queensland is a little bit different. First off, let's go to the principal. So I've actually got the appointment date from today. My daughter's coming up on, I can either leave this blank if I want, but she's coming up on Saturday. So we'll do all this on the Sunday. So until that point in time, my South Australian enduring power of attorney will take place or take precedence. So I've got Grant Abbott. I'll just simply put in my address, which is pretty easy. Now the next one is, and this is a little bit different than many of the other states, because Queensland splits out personal health versus financial. Now you can see here, so I'm looking at the personal health, and looking at the attorneys for that. Now you can have quite separate attorneys for your health and personal versus your financial, which is pretty obvious. Now, with our attorneys, you're going to see this coming through all of our EPOAs. Normally, if you're doing an EPOA, it's to do anything on behalf of the principal that can lawfully do by an attorney. So that's A-OK, but that doesn't really give you specific authority in order to act as a replacement trustee or replacement director. So we've inserted a separate clause to act on behalf of the principal for the superannuation fund only, including acting as a replacement trustee or replacement director, while this enduring power of attorney is valid and the principal have consented to them acting as such, which is the case. So because this is personal and health, I'm not going to tick the box of superannuation or replacement trustee, because that's not a personal health issue, that's more a financial. So I'll click do anything on behalf of the principal they can lawfully do by an attorney. Now, are there any terms or conditions that need to be set? Well, I've got no, but if I wanted to, I could click that box, and then you can put inside there terms and conditions that the client may specifically want around their enduring power of attorney. Now, is there more than one attorney? Yes, and I'll take you through that. Now then, how do they make decisions? Is it severally, jointly, majority, or is there some other way? So if we go another way, then we actually put in what that process is. Now I'm going to do mine as jointly, which means it's basically unanimous. So I then go down and start to appoint the attorneys. And remember, this is only for health and personal. So the first one I've appointed is Amanda Lynn Abbott, who is my spouse. So she's appointed, and I've added another. And you can see this on the left-hand side where I've added another person. So I go the next, and that's my daughter, Sophia Elizabeth Abbott, who's from Tuna Grove, Elwood, Victoria. So that comes up here. That's my attorney for see on the left-hand side, personal and health matters. Now, what we've got there is there the next one is, in the event of the death or incapacity of the initial attorney, do you wish to automatically appoint? So I've gone no, because if Amanda dies, then Sophia takes over, so on and so forth. So that's sort of got built in for that process. Now, if I wanted to, I could just go yes and appoint in what I call a successor. So you can see there, I originally put in Nigel and Chris, who are my brothers, but I've decided not to go down that track there for that. So I just click no, and that gets rid of them. So sorry, Nigel and Chris, you're out of my personal and health matters. Next one is, then I start to go into financial matters. So here I do tick the superannuation, and here I do tick again that the principal can do anything on behalf of the attorney. No conditions again. Is there more than one attorney? Again, jointly, if we go down the track. Now, notice how this is different, because the personal health only comes into play when I'm mentally incapacitated or physically incapacitated. So that's a personal health. Here, I can choose when will the power of attorney for financial matters begin. So I can do on a specified date on a specific occasion, but in this case, I've done immediately. Now, remember, for superannuation purposes and also for finance, the superannuation purposes, there still need to be a process that has to be carried out for them to become trustee or corporate trustee. And again, have a look at the Commissioner's ruling on that one, but I did cover it a little while ago. So I go to the next, and again, I've got the same parties. I've got Amanda, and I've got Sophia as well. But what I have done is I put in place my brother Nigel as a replacement attorney, so that if there's something happens to both of those, particularly when it comes to superannuation, etc., neither, if I put in Amanda and Sophia, they may well decide to retire or resign from that position. So I need to make sure, as you've seen on that roadshow and all the other stuff, that we need to put in place someone who's going to be the successor attorney. So, which I've done in this instance, I've put Nigel in, and again, I could choose another successor. So I could put Christopher, my brother, again, follows on from that. But I've just kept it pretty basic just for us at this stage. Effectively, you can go down a long way down the track. So this goes, this effectively now is the preparation of the document. And I just go next, and then that effectively pops up through. Oh, my interview session has expired, so sorry about that one. But I do have the one that I did before. So again, you've just got to be careful to make sure you save it, particularly when you launch. So what I've got here is this, the one that I prepared before. So this is for a Queensland. As I said, you can go through and do ones that really take focus in on each and every state you're in. So dated October the 31st, I'll go back. Remember, I relaunched it, changed the date. So what I'll do is I'll go back and I'll effectively change that over. And then when we print that out and sign it on Sunday, that'll be effectively. So this is a long form enduring power of attorney. I may go down the track and start to build these for the other states as well. But this breaks up personal and health and also financial. It's got some really good coverage. You know, when does the attorney's power begin? You know, how much control will they have, so on and so forth. So this is produced, as are most of them, from the state government website. So that's just simply to ensure that there's no really huge legal issues or copyright issues there. So Form 1, appointing attorney for personal health matters. I, Grant Abbott, a 30 Anchorage Circuit, Twin Waters, appoint Amanda Abbott and Sophia Elizabeth Abbott of 511 Tiona Group, Elwood, as my attorneys under enduring power of attorney for personal and health matters. Remember, we went through that. Authorise my attorneys to do anything on my behalf that I can lawfully do by an attorney. So then we go down. Do you want to give any specific T's and C's or limitations? So I could have gone yes, but remember I said no. And if I go yes, then those terms would basically come in here. For example, I want my attorney to try blah, 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 X, Y, Z nursing home first, which is again, that's quite sophisticated. We'll be building that into the SMSF living will, which will pop up early next year. So that's a very exciting new development that we've got at LightYear Docs. Are you appointing more than one attorney? Yes. How do you prefer to make decisions? So jointly, unanimously, or severally. Generally, I wouldn't go down that trace, or as a majority. And if it's a majority, we can put in there, for example, a simple majority, or that in the event that both Sophia and also Amanda disagree, then one of them has a binding vote. So statement of understanding, so that is now mine, so I fully understand, blah, blah, blah. So I'll sign there as the principal. And then we've got the certificate of a witness. So we've got justice of the peace, commission declarations, notary public, or lawyer who will do that. And then we go down and we look at appointment of attorney for financial matters. Remember, that was completely different. So the same thing here. I've got my authorise my attorneys to do anything on my behalf I can lawfully do by an attorney, but also acting as a replacement trustee or replacement director. So I'm getting a specific authority under here, which, look, I'm not overly comfortable, and certainly having the Commissioner's ruling that if we don't put that inside these EPOAs, whether they do have effect under both the state base and also the SISA Act. So to me, it's better to be safe than sorry. Our thing is always about being secure, certain, and also safe, which is why we do specifics in here. And you can see there that I've got Nigel coming in as a second, a replacement, and I can keep on going down the track. We go through the same stages, and then effectively what we've got there is We've got the statement of understanding. Again, from my perspective, remember I'm signing here for the financial and also the authority for superannuation purpose, which is crucial. We've got the significant witness to this form 2. And then we go down, and this is all relating to the attorney themselves, their responsibilities. And then we go down. So Amanda has to sign there. You can see here. So the first one is Amanda's acceptance, Sophia's, and that's for both of them. And then we've got Nigel again as a replacement. So that one is an EPOA for a, I might just go through, is for Queensland. I should have here, if I go into the vault again and have a look down at the Abbott-Family, I hopefully might have an EPOA for Victoria. There we go. So EPOA for Victoria, you can see there. So all I'll do is click on that, relaunch that one. In fact, what I'll do is I'll relaunch that so to show you what is a little bit different. So that's cracking on here. And so I've got the same thing. You can see there, principal, initial, replacement attorney, and signers. So there's no split in this one between healthcare and personal. So what I do is I put the principal's details in there. Now, this one is a little bit different, and you would have seen this on the roadshow. What I've done here is I'm solely doing this EPOA only for the purposes of acting as a trustee or replacement director of the trustee of the fund, as opposed to, for example, a complete one. So, so what I'll do is I'll go through this. So all I'm doing is just for the superannuation, not doing anything else, because I'm assuming that for the personal health and other financial, I've done it elsewhere. So this one I remember is John Smith. So we had Matthew Smith. And then we had the replacement attorneys being Marie and Sally together. And then there was the end of the interview. So hopefully this should pop up. So that's a pretty quick one. But again, this is only for superannuation purposes, as we see. So I go in and download the document. So just also shows you can go back and change details at any point in time as well. So I'll just go through this. And so this is a EPOA for Victoria, for John Smith. You've got here it's under Regulation 5 of the Attorneys Act. You've got Matthew Smith. In the event my initial attorney is unable to act as my attorney, blah, blah, blah. And then I've got here, the authorisation is solely for superannuation. So it's nothing to do with my personal health and other finances. So again, this is quite a specific one. Again, signed, and then we get all our witnesses there. So you've got those powers to, one, remember the Queensland, I could do both and they're separate. Alternatively, you could separate them out and do 2 enduring powers of attorney there. So we will build a process whereby, much like Queensland, you'll be able to do both of those. Harry has said, to what extent does EPOA maybe directly refer to a BN within industry super? An EPOA, that's a really good question. So where we have a power of attorney, effectively carries on until we lose capacity, for example. Then we need an enduring power of attorney to carry on beyond that. When we die, the enduring power of attorney ceases. And then if I take us back to our legislation, we will see here that our legal personal representative is actually going to be the executor of the will or the administrator of the estate. So effectively, your BDBN will carry on there. Now, the issue is, which is a good question from Harry, is can the holder of an EPOA effectively be given the power to change a binding death benefit nomination? It will depend on the deed. Certainly under our deed, I have given that ability. When you actually do your original binding death benefit nomination, you can put in a clause in there, as you'll see in a couple of weeks, that the enduring power of attorney is provided with the power to change the binding death benefit directions in one way, shape or form or another. So you put some T's and C's around that. Now, Harry, your question was around an industry superannuation fund. It would be interesting to contact that fund. In fact, it'd be great if you could contact them and give me some feedback on that. But I'm not sure whether they would see a change in a binding death benefit nomination in an industry fund prepared by an EPOA as being effective. But look, honestly, I would love to hear the answer to that one. As I said before, from our perspective, or from my perspective, under the deed, we'll certainly be able to do that. What I'm going to do is I'm just going to get Tony back on here and just unmute him. So we'll see. Are you there, Tony?
Good morning, Grant. How are you?
Yeah, good. I saw you like chastising your poor kids before. You're like,
I'm just
obviously got the work,
you know how they are.
do all the law and stuff like that. Yeah, do you just want to go through? Obviously, you've done a flow chart for EPOA.
Yeah, I just did a quick flow chart just now, just in relation to the flow, in relation to the EPOA and how it's going to work.
Yes.
From an external point of view, that will say I've tried to simplify the process basically, so that way clients or customers at the end of the day are not traveling to lawyer's office or whatever, so that way we can do it on Zoom straight away and have it all done and dusted as soon as possible basically.
So Tony's, if you have a look at the New South Wales EPOA, and this will be the same process. So that's only for New South Wales, but also when we get round to doing wills. Under the New South Wales EPOA, you need to get a lawyer's certificate. So what we'll do is Tony's got I'll send you out an email. Tony's got a process there where he can sign off on your EPOA and also your will. So if you're going to go through with a client and you're going to go through the interview, which we'll show next week, and you're going to get it signed off by a solicitor, which would be Tony, who's admitted in most states in Australia, then what will happen is you'll have a Zoom meeting with him, with the client. The client will sign off. You'll probably sign off as a witness. And at that point in time, he can sign off to and certify. So that way it covers you both your EPOA and also your wills and testamentary trust. Now, in terms of that, Tony, I just want to talk about capacity. So before doing an EPOA or before doing a will, why it is important to get a doctor's certificate.
Yeah, and what has to happen initially is through this process is that there's got to be a verification check and for the client it's like 100-point ID, and that's for our purposes and for your purposes also most importantly. Because that way you can identify the client. We can identify the client through the Zoom process to make sure that it is the client that's signing the EPOA at the end of the day. And what will happen next, and the importance of seeking a testamentary capacity from your client's local GP is basically that they've got testamentary capacity to understand what they're entering into, and what advice I'm going to give them at the end of the day, that they understand the effect and nature of this EPOA that they're giving to their attorney. That's what the importance is. But this has got to be done before the execution of the EPOA. And it's most important to do that, because if you haven't got that, then something happens in the long run, then it's open for challenge basically. That's what happens. And I've had these previously before. I've had these types of matters previously done, and I've challenged them, and I've been successful too. So it's important
to get that
have testamentary capacity before you sign an EPOA.
So I think if we go through the process in the system, so just to elaborate, you'll be able to go up, and if we have a look here on the LightYear Docs site, If I go to product categories, and I have a look at estate planning, which is coming up here, where we're at the moment with our EPOAs. We've got ACT, Queensland, Western Australia, Victoria, and South Australia. Now, all those don't need a lawyer's certificate. If you want to and get sign off from Tony, you can go through the process that Tony's talking about. But if you're preparing them on behalf of your client, these are actually taken off state government websites. So you're simply filling in the facts and the completing the interview on behalf of the client. Then you give it to the client, and then the client will get sign off. However, for New South Wales, you do need specific legal sign off, and the flowchart, which we'll send out, that Tony talks about, which is not only for your enduring power of attorney, but for your wills and estates, basically fits in there. So that's the crucial. All these other states, you're basically okay. But again, best practice is that the client, they need to tell the client to get a letter from their doctor that they do have a capacity to obviously sign. And it's not a bad thing anyway, because most of you acting as counsel planner have already verified their identity. So it's not a huge issue from that perspective, in that what we can do there is you've already verified their identity. The main thing that we need to do from that perspective is then go down the track of them just getting their testamentary or their mental capacity. So get them to do that. So that's not a bad thing to do. And again, from your perspective, so you can complete all of these, I would wrap it up if you're doing wills and estates, when we'll look at next week, do them all at once, which is a great process. Have a look at, do you separate your health and financial from your superannuation? Anna left me a question before, Anna Matai. So Anna, it's a really good question. So with that one is, can the accountant act as an EPOA? Yes. You can see, remember we saw in the when we went in, if I have a look here, if I've still got it open, no, I don't think I've got it open. What I'll do is I'll show you how to do it for the Queensland one. I'll relaunch the interview. If I wanted to go in and limit, I could, for example, so the interview is just popping up. And remember, you can relaunch. So I've got that all there. So let's say I go into the financial matters. So I click on the left here. See, I've got Amanda, Lynn, and all that. I could put in, for example, Sam, accountant, so on and so forth. But what I would do there is, I've got their superannuation fund, do anything I can act. So I could click that out, and I could put terms and conditions there. If that was the accountant, I could say my accountant, Sam, accountant, has my power of attorney to complete my taxation and legal affairs. So that term and condition will now pop up. And again, if you start to getting really detailed T's and C's, that may be a place where you do want to obviously get sign off from Tony. Again, from Anna, if we have a look at what's the responsibility of that accountant if they do an EPOA. Again, if you have a look, what you're doing from this process is, this is actually just state-based. So we're taking an interview or a fact find of your client, providing it to the client, and then the client is, so the process is, the client, you get the EPOA for the client, sit down, get your instructions, complete it there, complete the interview, and then at the end you provide that then to the client. And then if need be, particularly in New South Wales, if you want to get sign off from Tony, send it down to him, set up the Zoom meeting, go down that track. From your perspective of how to charge, you'll just simply charge as part of the process of your superannuation. So it's the conduct of superannuation affairs. I would say that the cost here is much the same as investment strategy, between $380 and $400. If you came in, and I'll just ask Tony there, I think when we have a look at Tony, what's the normal costing if you go to a solicitor to get an EPOA? It's quite expensive.
Yeah, yeah, they are, because normally solicitors charge for EPOAs anything between $660 and $800. So yeah, that's the going rate. And if they have to attend on site at the end of the day also to come to your place or go to a hospital or go, you know, a fair distance, they will add those costs on top also. So,
You know, I think it's important anyway, if we go down to superannuation, to make sure that everyone has an EPOA. As I said on the roadshow, we could have, for example, a 4-member fund. And on the roadshow, we looked at John and Sally Smith, Matthew Smith, and also Marie Smith, with potentially the boys coming in, which were Matthew's boys, Ben and William. So it's fun when it eventually comes. From that perspective, what we can do there is ensure that we can have, just for example, two trustees or two directors of corporate trustees, say John and Matthew, particularly if you're using leading members. And then effectively what will happen is then, as long as they've got EPOAs over other people, then that would be perfect. And obviously where you've got children under 18, the parent basically can come in from that perspective. Again, another one, Anna, which is great. So do you have marketing blogs so we can send out to our client? So, for example, what I will do from that, and thank you, Anna, for that. It's a great idea. Much the same, if you remember the letter that we did for the investment strategy, which you no doubt you can find up here on the support centre. What I will do in the next couple of days, I will do a letter. So remember, there was this letter for the investment strategy. I'll do a letter around enduring powers of attorney, much along the same lines, and the need to focus in on getting it ready for SMSFs, specifically in superannuation, particularly if someone goes overseas. And also alerting to the fact that, particularly for a lot of your clients, I don't mean to be not disrespectful, but look, I know from having a look at my family, Dad and Mum were in the fund, as well as my brothers. Mum should never have been in the fund because it just created too much stress for her to actually be trustee and having responsibility. And particularly now the Commissioner is focusing on trustee responsibility. I think you should have less trustees than you actually have members. And the way of doing that is an EPOA. So what I will do, Anna, I will come back and I will do up a letter there for you if you think that's perfect. I've got another question here from Harry. Can a member of an SMSF name a testamentary trust under BDBN which may hold an EPOA, of the member? So I would say, let me just think about that one. Can a member of an SMSF name a testamentary trust under a BDBN? Generally, Harry, you'll see next week and the week after that we could effectively do that. So a lot of these ideas that you're putting to me now, I'm going to have to put as specific options in the binding death benefit directions, but it is possible if you want to do that. Or the appointment of an EPO requires to be an individual. Okay, so not necessarily we can have companies as EPOAs if we want to, etc. So what I'll do is, if you want a specific issue looked at, Harry, and that way I can then cover it when I come and have a look at our wills and testamentary trust next week. Just jot a line to me at grant@ilovesmsf.com, and then what I can do is I'll have a good look. But again, that's a great question as to where it fits in. So we'll go down again from Anna. Is an EPOA required for each person in a member of the SMSF? Yes. So what you'll need to do is, if you're going overseas, then the first thing you need to do is get your EPOA taking control as trustee of the fund. I would go down the track and personally put in place EPOAs for every member of the fund, along with an application as well. I think it's better to have those on file rather than not. Now, again, it doesn't mean that it is a vote at that time. So we have to go through the process of resigning as trustee, or if they're a new member, they can just simply be a member without being a trustee because their EPOA takes control as a replacement trustee. But the last thing that you effectively want is a process whereby the EPOA or person, as Tony said, loses their capacity or mental capacity, and then effectively we can't do an EPOA. So then you're sort of stuck in limbo land and having to go and spend a fortune to get it. Look, but that's, anyway, what I'll do is from this process, I'll send through Tony's flowchart. I'll send through this recording in the next day or so, along with a letter for you to send out to your clients around the EPOA, again, with a suggestion on the charge of you done that. Marie, what I would suggest is I'll also put in some ideas around needing to have an EPOA for every member. And the fact is that they can just do this one for superannuation only. Anyway, thank you very much for attending today's session, and hopefully you've got a lot out of it. Again, make sure you register for next week, which is a really groundbreaking session for us, which is on wills and testamentary trusts. And again, thank you very much, Tony, for attending today's session and giving us your deep insights. And let's see, and we'll take it from there. Anyway, it's Grant Abbott and also Tony Anulis signing off from our EPOA session. Thank you.